Well, we want to start with some of the most pressing legal questions in this historic case. So to get us started, joined by NBC News Justice and Intelligence correspondent Ken Dilanian, and then with our legal analysis, I got NBC News legal analyst Danny Cevallos, and Tim Heaphy, a former U.S. attorney who served as the lead investigator for the January 6th committee. And, of course, they had their own criminal referrals that they sent to justice. So, Ken, let me start with you. I think that it was interesting to see the speed with which we got the indictment yesterday versus the classified documents indictment. I'm just curious, is this the special counsel's office sort of learning a lesson here? Boy, they allowed Trump to fill a vacuum for about half of a news cycle the first time. They didn't allow that this time.
I think that's a reasonable supposition, Chuck, although I will say there were some complexities in the classified documents rollout that didn't exist here. For example, they had to notify certain elements of the intelligence community about material that was going to be in the indictment, and they couldn't do it while it was sealed. So there were some things going on behind the scenes that delayed it. And it's also true, though, that they unsealed that indictment in Miami more quickly than they had planned to, as they realized that Donald Trump essentially had the floor. And it seems it seems certain that they were intent on making sure that didn't happen here, because you could just see the care with which they took to do the public rollout. It didn't go exactly as they had planned, but they got it out quickly. They had Jack Smith out. He didn't have to make a statement, but he did that. And the indictment is written in plain language, designed clearly to appeal to the American public as well as a jury. When you say, and it's very rare that you say in an indictment what a defendant had the right to do. They started with saying he had the right to say that the election was fraudulent. He even had the right to lie about it, but he didn't have the right to engage in an alleged criminal conspiracy. Chuck.
Yeah, that's interesting. You point that out. You don't often see debate talking points in an indictment, is essentially what you're saying, right?
Yeah, exactly. So it really seemed written to persuade.
Anything else to glean from why Jack Smith chose to do an on-camera public statement? He didn't have a lot to say, but it seemed like the symbolism was somewhat mattered to them.
It feels to me like they really believe there is a public education function that they need to do here, that this isn't just, they're not just speaking to the legal community and the potential jury pool, but to the public writ large. And it was also a kind of a concerted effort to make sure Merrick Garland had his say as well. He was at a public appearance in Philadelphia. There were cameras there. He answered a question. He essentially asserted Jack Smith's independence, even though, of course, Merrick Garland has been briefed on this case all along, and he had a chance to block this indictment. He chose not to. But I thought all that was interesting, and it was all by design.
Couple of quick things. One, do we feel like we have a good idea of who's fully cooperating and who isn't? I mean, I assume now with Mark Meadows being portrayed very honestly, at least in the indictment, hard not to think he's not cooperating, correct?
Well, no, I'll tell you, we do not have an idea. That is unknowable, really. But and because I'll tell you this, cooperating could mean different things. Mark Meadows may be cooperating in the sense that he is complying with grand jury subpoenas and turning over everything that he's supposed to turn over. Or it's possible that he or others could have cut a deal and be, and be subject to criminal prosecution and are cooperating in that respect. Those are two different things, and we really don't know if there are anybody in that category out there, that there are sealed criminal informations with actual cooperators who are, under the gun with criminal prosecution. We don't know the answer to that. It's certainly plausible, though, and it's plausible that some of these co-conspirators could take a look at the charges arrayed, potential charges arrayed against them, and decide to cut a deal themselves.
There's a little bit of action in the other Jack Smith indictment and investigation. He's asked for a hearing in the classified documents case in front of the Florida judge on conflict of interest issues with one of the defense attorneys. Walk us through it.
Right. So it's a man named Stan Woodward, who has represented a number of different people in various of these investigations, and his bills appear to be paid by the Trump super PAC. So that's important to know. And the special counsel is raising an issue of potential conflict of interest because essentially he may end up cross-examining his own client on behalf of another client, and that's a problem. There's also an issue with he's representing people who appear to that the special counsel would badly want to cooperate, but they are so far remaining loyal to former President Trump as their lawyers' bills.
So what is he hoping for from the judge? that the judge is going to say he can't represent all of these folks at the same time? He wants the judge to force this issue?
That's possible, although I heard Andrew Weissman say today that this may be a waivable conflict of interest if the client says that's okay. But look, you know, I feel like the special counsel feels like they have to pursue this remedy just to make sure that it's on the record. All
right, Ken Dilanian, getting us started on the Justice Beat for us. Ken, thank you. All right, I got the prosecution side essentially and the defense side here represented with Tim Heaphy, who assisted the January 6th committee, former U.S. attorney himself, and of course, Danny Cevallos, who's made his living as a defense attorney here as well. So I'm going to try to get you guys on to sort of stay in those lanes for this. So, Tim, let me start with you. The criminal referrals you guys made, January 6th committee made to justice, you feel pretty vindicated by what Jack Smith turned in yesterday?
Yeah, look, the facts have been obvious, Chuck, for a long time. The special counsel relied on the same facts and reached the same conclusion that we did, that those facts give rise to the violation of several federal criminal statutes. Obstruction of an official proceeding and conspiracy to defraud the United States were precisely the statutes that we referenced in our criminal referral. Not a surprise, right? Facts make cases, evidence wins trials, not lawyers. And the facts have been fairly obvious here for some time.
It seems like if he got additional information, it was arguably because he seemed to have a few more tools. I want to look at the Mark Meadows excerpt in the indictment, and I'm just curious if how much you wish you could have gotten more from Meadows. A day after the defendant's chief of staff personally observed the signature verification process, the Cobb County Civic Center notified the defendant that state election officials were conducting themselves in exemplary fashion and would find fraud if it existed. The defendant, meaning Donald Trump, tweeted that the Georgia officials administering the signature verification process were trying to hide evidence of election fraud and were, and then brackets, terrible people. What were the tools that Jack Smith, do you think, had that got more out of Mark Meadows than you guys were able to?
Yeah, so when there's a criminal investigation and a grand jury proceeding, any assertion of privilege can be immediately adjudicated by the chief judge. Mark Meadows, as you know, sort of halfway cooperated with us. He gave us a lot of text messages, were really important, but then refused to come in and submit to the deposition, even though he'd been subpoenaed, claiming executive privilege. Essentially, his argument was, look, as White House Chief of Staff, I am immune from congressional oversight and don't have to submit to the Select Committee. Our only option was civil litigation, which takes a while. We did not have the time because we were on a time clock. We were expiring at the end of the Congress to take that claim to a judge. We thought it was meritless, but we did not have the enforcement ability. Jack Smith goes right upstairs to the chief judge who supervises the grand jury, and that judge immediately makes a ruling. He hears from Meadows' lawyer, he hears from the special counsel, and he makes a call, and then it immediately goes to the Court of Appeals on a motion to stay. So he has that hammer to sort of quickly push through privilege assertions, and he has used that effectively to get access to information that we did not have.
All right, Dana, let me bring you in here. When you read this indictment, as Trump's defense attorney, do you think is the toughest part of this indictment for him to fight?
Let's start with the facts. Not a lot in the way of facts is a surprise to any of us. So for those of us who have been following along, there aren't a lot of surprises in the indictment. So knowing that, the hardest part of the case has always been what it was for at least the last year, since the January 6th committee elicited a lot, if not most, of the facts that we see in the indictment. So the real question, the only question remaining, was whether or not Jack Smith's team thought those known facts fit into particular federal statutes. And so now we see that obviously they do. I think any federal case is a bad case for any defendant because the vast majority of federal cases end in conviction. But I think for me, the most damning thing for Trump, if you think about this from a defense attorney's standpoint, everything goes to his intent ultimately. And then also there's a defense that, hey, these were my minions, my buffers. They acted independently of me. I didn't know what they were doing. But really at the core of this, all Trump really has is an intent defense. And so we see them, the government, refute that in the list of people that told him that this was a bad idea.
If there was not such an organized elector scheme, right? Take that out of it. Do you think his First Amendment defense would be stronger?
Sure. I mean, the elector scheme is the most concrete to me. And really,
that to me is what makes this, to me, so much harder for him to use a First Amendment defense.
Exactly right. But then again, the elector scheme has a lot of people working at Trump's behest. You have your Giulianis, right? You have even people working with Giuliani. You have a lot of folks that Trump might point to and say, hey, that Giuliani guy, he was a rogue actor. I didn't know what he was doing out there. I don't even understand the government.
This is what Trump did to Michael Cohen.
Oh, absolutely.
I mean, so why wouldn't? I mean, is the best defense, you know, it's funny, he's worried about people flipping on him. Should he flip against his co-conspirators?
By flip, you mean, can he go into the government and enter into a cooperation agreement? The government's not interested in that. Number one, he's the only defendant. Right. So there's no one really right now for him technically to cooperate against. The government wouldn't be interested in that. I expect if he went into the government would give him an offer that I've gotten plenty of times, which is your client can plead to the indictment. In other words, he can walk into court. We won't make any recommendation. He pleads to everything in the indictment. Sometimes in federal court, it's so bad that is an option, but that's not going to happen in this case. Not a chance. So, look, I mean, Trump is going to blame other people, right? But the government knows that, and he's also going to claim massive ignorance. But again, the government knows that, and that's why they have all those facts in there about all the people that told him what was going on. But look for him to, with those Rudy Giuliani and electors part of it, look for him to say that was Rudy operating on his own.
Tim, when you've brought a set of charges, look, more people other than Donald Trump committed crimes here, as alleged in this indictment. But Jack Smith chose to single out Donald Trump and not, and it is... How often have you done that? And is that done simply to get a speedier trial?
It's rare. Usually you want to charge all the conspirators together in a single indictment. You don't want to try the same case or present duplicative evidence in multiple trials. The difference here is the DOJ policy about refraining from taking any enforcement action anywhere close to an election. They have the target of this investigation, the defendant is running for president, and therefore there is some haste to bring this case, take this action well in advance of when people start voting. My guess is those other conspirators are not off the hook. There may be subsequent cases. Some of them may end up evaluating exposure and potentially reaching some sort of a deal. Very hard to say. Very common in conspiracy cases for conspirators themselves to end up being witnesses against others, as your questions, Danny, were just suggesting. So this is not the end of the proceedings here. It's really just the beginning.
And Tim, were you surprised that incitement wasn't included or not?
You know, that raises more of the First Amendment defense, right? Speech is protected by the Constitution, as it should be, but conduct is not. That's the line that the jury will have to draw. If President Trump stands up and says the election was stolen, and that's his right. It's only if he says that as part of a scheme to actually take action to disrupt the joint session, the transfer of power, that it becomes criminal. So the incitement statute, you know, aid and comfort to an insurrection, those are vague terms that do get closer to speech. I think he's charged this surgically, looking for a speedy trial, avoiding some of those legal issues is the best chance of getting this resolved before the election.
Danny, how would you try to avoid a speedy trial here? I mean, he's made it hard. What's your sense of how likely Trump is going to be able to delay this until after?
There's a paradox going on here. The speedy trial rule is designed to protect defendants. But in federal court, often the speedy trial rule can be better for the government. It's no surprise to me that Jack Smith, a man of few words, found a way to crowbar in the word speedy trial in his very short statement, because a speedy trial benefits the government, particularly in a case like this, where they've been investigating for years. Admittedly, Jack Smith started in, I believe, November of last year, but they've been investigating for a long time. Meanwhile, the defense hasn't gotten discovery document number 1. So in a strange situation here, although not that strange, the government is ready to go to trial probably tomorrow. It's the defense that needs time. So this is a case where speedy trial would inure to the benefit of the government. That's why they're going to try and essentially enforce the defendant's rights.
Sure, but what's Trump's best tactic to delay this?
look, argue that the case is unusually complex. The Speedy Trial Act allows for a delay. But I've had judges that when you make that argument, they say, OK, fine. And they move the trial out 1 month. Yeah. Gee, thanks. That's not a lot of help. Federal judges like to keep their docket moving very quickly. This is not state court where congestion will lead to delays of a century. Cases move quickly in federal court.
Danny Cevallos, Tim Heaphy, I got a lot more questions, but I don't have enough time right now. But I think we're going to hear from both of you a lot, I hope. Thank you guys for helping us navigate this indictment.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.